Ladies and gentlemen, this is Professor Slabbert. We've got a minute to go. So let's just give a minute for everyone to join. If I can just ask, please, that you all mute your microphones and switch off your cameras. Otherwise it takes too much data. And then at the end, when we do questions and answers, I will switch on my camera and we can interact. Can you all see the screen?
Yes.
Yes, I can see the screen.
Yes, we can.
No, I made a mess. Hey. Okay, let me just see. Can you, if I share the screen, can you all see? It's not there now, but I cannot see my PowerPoint and the participants. So just give me a thumbs up if you can see the screen. Okay, then I'm going to share it again. And let's start. Let's from the beginning. Okay. So good evening. This is Professor Magda Slabbert. This is the first webinar for your module, Introduction to Medical Law. Bonnie Venter is your facilitator. I am more in the background. I do the webinars and I oversee the work of Bonnie. So welcome to all of you and thanks for joining us this evening, and I hope you enjoy it. Okay, so who am I? I am a professor at the University of South Africa. I do not teach medical law. I teach legal philosophy and I used to teach ethics. And I'm old and I've been in teaching for many years, but my passion has always been medical law. So my doctorate was in medical law and all my publications and all my research is in medical law in the wide sense, not just medical negligence. The other field that I'm an expert in is organ transplants, but also generally on different topics within the medical law umbrella. Who is Bonnie Venter? Bonnie Venter, your facilitator. She used to be a master student of mine. She is brilliant. She is now busy with her own doctorate. She is much younger than me. I can be her mother, but she is technologically far more advanced than I am. So she is dealing with everything on your website. I am more in the background. So we do not know who all of you are. So if you want to, you are welcome to go to the forum and introduce yourself, say where you work, what your interests are, etc. But that is a choice. It is just a little bit for us to see who is the participants that we are teaching. You are also welcome to ask questions on the forum, and you are welcome to help each other. But of course, at the end of the day, when you do your activities, you have to do your own work. If you have specific questions for me, there you can see my email address and you are welcome to send me an email. Please just indicate that you are a participant from the lead course, because I get a lot of emails from students and then, as I've said, I'm not that young, I can get confused, but I don't mind. If I don't have an answer for you, then I will find out and come back to you. As a matter of interest, you can post your questions also on the forum, and then either Bonnie can answer you, or you can help each other with this module or with questions, etc. Just note that when it considers admin matters, then you have to ask Grace Makuru, because we are not involved in the administrative side of this module. By the way, you will get these slides. So when I'm finished tonight, I will send the slides to Bonnie, and she will post it on your website tomorrow. Unfortunately, we do not make the recording available, but you will get the slides, so there is no need for you to keep on writing everything that I say. You will get the slide, so you can sit back and just listen to me. And I apologize from the very start. You can hear that English is not my first language. So forgive me if my English is terrible, and forgive me if I talk a lot and if I talk fast. But there's a lot of information that I have to transfer in the 2 hours. But as I've said, you will get the slides, so you can always go back and then you will remember what I've said. You must keep your eye on your schedule so that you know when is what expected of you. For instance, today, I apologize. I see on the schedule, it was scheduled for 4 o'clock. That was an oversight from Grace's side, as we've decided to do the webinars from 5 until 7, so that more people can join, because usually they are done or finished working. So please keep the eye on the schedule. Bonnie will also indicate there when she's available and when you have to submit your different activities, etc. Bonnie will also be once a week online. That is not for you to interact with her as we do now. In other words, it's not a Zoom or a Teams meeting, but she will be in front of her computer, and if you post questions on the forum, she will respond. So that's what it means, is that she is available to answer questions, but it is not an interactive session as we have now. And as I've said, you can email me anytime. I will try to respond as fast as possible. And if I don't know the answer, then I'll find out and come back to you. So Bonnie will be online once a week on Wednesdays from 5 until 6. So just keep that in mind. Otherwise, if it doesn't suit you that time, post the questions anytime on the forum and Bonnie will respond. If she doesn't know the answer, she forwards it to me and we work together. Then also keep your eye on the announcements. Sometimes I come across articles which I think might be of interest to you, or old articles that I think will be of interest, and then Bonnie will either post it under announcements or extra reading material, etc. Remember the extra things that we post on the website is not relevant for the test. In other words, the extra that we give you is for interest only. It is because we are so passionate about medical law and what happens in the field that we want to share as much as possible. But we do not expect you to go and study all that work. So if you have time, if you've got nothing to do on a Sunday afternoon, you can read through these documents or articles or whatever we find interesting, but you do not have to study those documents. Okay, so how are you going to get your certificate? First of all, you will have to write a test 1, and that test will be online. It is multiple choice. It will open on 29 August and it will close on 13 October. You can do the test anytime when you feel you have mastered the theory. So you decide between that time, 29 August, 13 October, when you are ready, and then you do the test. And that is what we call test 1. and that will be 20% of your final mark. The test is based on the theory. What do I mean by that? Each study unit has theory. The test is only based on that, nothing else. In other words, not the webinars, not the extra reading that we give you, not the activities. You only study the theory. For example, your first study unit is medical law and the Constitution. So you will go to the study material and you will go through that. That is important for test 1. The same with the doctor-patient relationship, or the third one, medical negligence, etc. The theory, as it is your official study material, only that is important for test 1, not the extra material or the portfolios or the activities. So make sure you understand that. So on your own time, you will go through the study material, which I call the theory. Once you feel that you have mastered it, then you go onto the website after 29 August, you open test 1 and you do test 1. And you have until 13 October. That is the one part of how you are going to be assessed. The second part will be the activities and the portfolios. Well, the portfolios is just the activities together. And the activities, you will get activity 1, activity 2, activity 3. You combine that into one document, a PDF format, and you submit it as portfolio 1. And then you will get activity 4, activity 5, activity 6, and you will combine those 3, and that will be portfolio 2. Please just remember to have a sort of a title page with your name. Sometimes students just upload their portfolios without a name, and then it makes it difficult for us to know who is the person answering. So in a PDF format, have a title page with your name, and then please number your activities so that we can see this is activity 1, and the subsections activity 2, and the subsections activity 3, and the subsections. Plan your time. So you will see there on your screen that I've put that in capital letters and a lot of exclamation marks. The biggest challenge in this course is not the content. The content you will love, and it will be meaningful, and you will understand it because of your background, either in law or in the healthcare professions. But time is the catch here. If you think activity 1 has been posted, if you think, oh, I'm going to leave it until next week, you're going to run out of time. The biggest challenge, as I say, is time, because we expect a lot of you. So you will have to plan your time. Okay, so as I said, be active on the forum. You can interact with each other, but you do your own work. And then please never give up.
5, but I
Ask for
didn't
help.
know the sound,
You've paid a lot
wasn't
for this
working.
module,
That's
and
like
it
a
is for
block
me
in
and Bonnie to help you to pass it. So never give up, even if you run out of time and things start getting chaotic. Make contact with us,
Sorry, it's very.
explain to us, we will
Somebody's
see
not
where we
muted.
can help you. But remember now, you've been warned that you have to plan your time. So the 2 portfolios will together count 80% of your final mark. So remember, I said the test 1, the theory, the study material, 20%. The portfolios, 80%. So you can see the biggest emphasis will be on the portfolios. So please put in an effort. What will the activities be like? Those are broader than the study guide. In other words, I assume that all of you can read, so I do not ask questions from the study guide. That is your knowledge, your background knowledge. In the activities, I focus more on the fact that you should see how the theory plays out in reality in a court case. In other words, the activities, to put it in a nutshell, is court cases, and then I ask questions on the court case, which might resemble a comprehension test at school. Now you may think, why does she do that? The reason is I want to force you to read the court case. Why? Because I feel in the field of medical law, there's something in that court case that I would like you to know forever. It is not necessarily part of the theory that you have studied, but it's an application of the theory. So I'm forcing you, well, Bonnie and I are basically forcing you to read 6 court cases. And in the process, answer questions about that, because then you have to read with attention. And that, at the end of the day, will count together for 80% of your mark. So activity 1 has been released. Next week, you will get activity 2. The week after that, you will get activity 3. Once you have done all 3 of them, combine them together with a title page, PDF format, submit it online as portfolio 1, and that must be in by 13 September. If something really bad happens, a court case comes up, you have to go to Bloemfontein, the Supreme Court of Appeal, whatever, please send an email to me and Bonnie, and we will try to accommodate you. But we do not accept that you just forgot. There must be some or other reason. Otherwise, it becomes everything goes, and we can't accept that. Then after you've submitted, while you submit portfolio 1, that following week, you will get activity 4, then activity 5, then activity 6. You combine the 3, that will be portfolio 2, and that must be submitted by 12 October. I stress once again, the activities are not difficult. In other words, we do not want to catch you out. We do not ask questions that is not possible to answer. It is easy, but it is time consuming, because you have to read through the whole case, then you read the questions, and then you go back to the case and find the answers. So time is more an issue than the difficulty of the questions. And as I've said, the reason why I've prescribed those 6 court cases is because I feel there's something worthwhile for you to take note of. And then lastly, ask if you need help. Okay, how do we assess the portfolios? Remember now, that's 80% of your final assessment. We look at each activity in total. So we ask, did you understand the question? Did you do what was expected of you? In other words, did you answer the question? Did you understand the principle or principles that was tested? Did you put in an effort? And then lastly, we look at your overall portfolio to get an impression whether you share our passion, whether you enjoyed it, and whether you are proud of your work. Remember, when you study as an adult, it is so much different. Just after school, when you finish school and you go to varsity, you go and you want to meet your future husband or wife, and you want to be seen to be cool and whatever. But now as adults, when you do a course like this one, you do it because you want answers to questions. You want knowledge. So we want, or we would like you to be proud of your assignments and your portfolio. And might I add, if you pass this module, and even if you passed it very well, you must be so proud of yourself. This is not an easy course. I said the questions are not difficult, but the time planning, what is expected of you, that is challenging. So if you pass this course and if you pass it well, then go outside in the world and brag, because then you did work hard. So at the end, we would like all of you to pass and feel satisfied that you know something about medical law. Okay, so the study material, the theory that you need to study for test 1. I want you to note that that is not original work. In other words, it is not something original. I used a lot of sources to compile the information, and there you will see the list of sources. I just once again stress that you will get these slides, so you need not make notes. You will get it and you can go through it on your own time. The first book is Carstens and Pierre Main, Foundational Principles of South African Medical Law. Unfortunately, that book is out of print. So what I suggest you do is on your social media, whether you are on Facebook or wherever, ask whether there is anybody in this whole South Africa who has a second-hand one that you can buy, because there are no new ones available. The book is being updated, but when the new one will be available, I don't know. So if you can put your hands on a second-hand one, go for it. The next one is Dye and McQueen Mason, Bioethics, Human Rights and Health Law, Principle and Practice. That is a Utah publication. The first publication was in 2011. An updated second edition came in 2020. Very, very, very handy book to have close by you if you are going to practice in medical law, or even if you are in the health professions and you want to know answers on certain issues. Very nice book. It reads nicely, nice referencing, etc. The next one, Moodley, Medical Ethics. That is a 2011 publication. That is more if you are interested in human rights law. So, for example, are you working at the Commission of Human Rights? I can't get on their full name now, but anyway, if you're working with human rights, that is a nice book to have. Although it's a little bit old, 2011, I'm sure a newer edition will be out there someday. McQueen Mason and Dada, the A to Z of medical law. Excellent, excellent, but only for referencing. In other words, that book is like a dictionary. It is where you quickly go to get the basic grasp of the issue, and it guides you where or what subjects you have to combine with this issue. A quick reference, although it's 2011, very, very, very relevant and worth the money. To have that next to you on your desk to quickly go and see. Let's say someone comes to you about surrogacy. You can quickly go to that book, see the details of surrogacy, get the pointers where to research further, etc. The next one, Van der Heever and Lawrenson, Expert Evidence in Clinical Negligence. If you are a practicing attorney and you would like to start practicing in medical negligence, you cannot go without that book. It is excellent. It is a must to have. Why do I say that? Because medical negligence cases can only be won in court if you have an expert. And that book explains to you how to negotiate with an expert witness, all the forms, all the necessary things that you need. How do you get documents from hospitals or doctors? There's even forms at the back that will help you to practice in medical negligence. Excellent book. Please get hold of that. It's not a thick book. It's not an expensive book, but it is an excellent book. John Sainer, SC, Medical Malpractice in South Africa. That is very expensive. It is from LexisNexis. It is loose leaf. So maybe if you work in a law firm, you can ask the law firm to buy it, and it is updated. The last update that I received was in 2021. So it is updated regularly. Excellent. Also gives you examples of forms and lists the processes that you have to go through. But as I say, that is a little bit of quite thick for your pocket. So if your practice can buy it, it is an excellent investment. The next one is the quantum of damages. That is for you just to see more or less how quantum is calculated, but usually that is done by an actuary, but it will give you a guide or a direction to go. So that is also a good book to invest in. And then for free, and that is why it is in red, you don't have to buy these. Never forget the Health Professions Council of South Africa. They have booklets with a lot of information in that, and that you will find on the website of the Health Professions Council of South Africa. So whenever they are updated, usually, so whenever you are dealing with some or other matter, you can go to the website and you can download these booklets. So that will not cost a lot. So if I can suggest, if you are starting in medical negligence, I will suggest that you buy the book, The A to Z of Medical Law, and that you will buy Van der Heever and Lawrenson. That will help you immensely. And then if you are established, you can take out the money and buy the John Sainer Medical Malpractice in South Africa. But these are the books that I use for general research in order to get answers to questions. What are the outcomes for this whole module, and then also relevant for the test? First of all, we're going to look in study unit 1 at the Constitution and its impact on healthcare and access to healthcare services. Then we are going to discuss the doctor-hospital patient relationship. What does it entail? What is the bottom line of that relationship? Then the third bullet, the most important of this whole module, is medical negligence. What is it? How does it impact on civil and criminal litigation? How is it established? How do you handle those cases, etc.? Then we're going to look at the grounds of justification. For example, now you appear for the defendant. What could possibly be the grounds of justification? That will be of interest to those of you working for the state attorney, etc. Then we were briefly going to look at the influence of legislation and also the disciplinary processes at the HPCSA. And then in between, you have practical exercises. The practical exercises that you were given on the website are just examples of what medical cases can look like. We do not provide model answers because every attorney will answer it differently. So we just want you to see those things. So you're not being tested on it. You don't have to submit it. It is just to show to you examples of how possible cases could look like. Okay, to start, I have recorded there a quote for you. It is from a private hospital, Mediclinic versus Vermeulen, and it happened in 2015, SCA in the Supreme Court of Appeal. And there the judge said the following: we should be doing a disservice to the community at large if we were to impose liability on hospitals and doctors for everything that happens to go wrong. Doctors would be led to think more of their own safety than the good of their patients. Initiative would be stifled and confidence shaken. A proper sense of proportion requires us to have regard to the conditions in which hospitals and doctors have to work. We must insist on due care for the patient at every point, but we must not condemn as negligence that which is only a misadventure. And I want you to never forget this in this few weeks that we are spending together. Not everything that goes wrong in a hospital is necessarily negligence. And people do not understand that. They go to hospital, they go for an operation, they get out of the operation, everything went well, but then they contract septicemia, their sepsis. It is not necessarily negligence. In other words, if you cannot prove that it is due to negligence, you do not have a case. It may be a misadventure. You may be angry. You may be furious against the hospital administration or even the doctor. But everything that goes wrong is not, and I repeat this, not necessarily due to negligence. Keep that in mind. As we go on, I will refer back to this. So this is the first thing of importance that you must remember tonight, is that everything that goes wrong in a hospital or with a doctor is not automatically negligence. We must apply the test, etc., etc. And that is what you are going to study in this module. So there I just give a picture. It's a little bit of old picture, but it is just showing you 2012, 2013. That's old. So I've jumped here. If you Google medical brief, you will see there is a whole division on the website for medical legal matters. And I got this information from medical brief. So for 2020-2021, 8.5 billion would have been paid out for 878 cases. And then it is broken down in the different provinces. But just briefly, I mean, but please don't laugh, but I don't have a feeling for numbers, so I might say the numbers wrong, but just throw your eye on the screen and you will see that the numbers are huge. Those are the claims. Those are the claims instituted in the different provinces. And there we have 2021, 2022. It is just becoming worse. But there's an interesting comment there, the second line. Fewer cases were recorded, but the value of the claims increased significantly. Now you will all agree with me, this is not sustainable. It cannot go on like this. Let me give you background. South Africa has a National Department of Health, and we have a Minister of Health, Minister Pagla at this moment. But then the 9 provinces, provincially, has a MEC, a member of the Executive Council, or some call it the Executive Committee, but that person is at the head of the Department of Health of that province. So how does the money work? Every year during the budget, a certain amount is allocated for health, and that goes to the National Department of Health, who then distributes it to all the provinces, the 9 provinces. So every province with the MEC at the top will get a budget for that province. But now remember, that budget needs to cover everything: the medicine, the beds, the salaries, the cleaning staff, the cleaning material, everything in hospitals, in the public sector must be covered by that budget. Now, if there's negligence and there's a case of cerebral palsy proven against a gynecologist, then because that person works for the government in a public hospital, the government becomes responsible for that amount claimed. And that amount can be 25 million. So if the parents of this child suffering from cerebral palsy wins the case and get the 25 million, it goes out of the budget of that province. So there is less money then to buy medicine, to pay salaries, to buy new beds, to buy equipment. So it is becoming a big, big problem. So the South African Law Reform Commission saw that this is going haywire and it is not sustainable. So if you Google, and there I give you the email address, go to paper 154, project 141 on medical legal claims. Also look at paper 33. There's immense lot of information in that, and you will benefit from reading that. But what they argue in those documents is that there need to be a different way of dealing with medical legal claims. In other words, they're proposing mediation or the capping of costs. Or the capping of cost, etc. You can read it and see whether you agree or not. Then, as I've said, also go to the website of Medical Brief. There you will also get some information. You can even go to the website of Corruption Watch and see how they expose the critical state of the health sector in South Africa. Remember, these are just broad information. It is not relevant for the test or the activities. It is there for your own information, depending on whether you are practicing in this world or whether you just do it to know more. So those are extra. It is not compulsory. Okay, then you will also see that sometimes people speak of health law, healthcare law, medical negligence, medical malpractice. It depends on the context. What are they referring to? Medical law in general encapsulates everything. In other words, things like organ transplants, in vitro fertilization, surrogacy, sex changes, all those things will fall under medical law. Healthcare law will more concern the rights of the people working in the healthcare professions. And then remember, when you read overseas cases or documents, they speak of tort law. Tort law is the same as a delict in South Africa, and that just means that the right of one individual has been infringed upon, and another person is responsible for that. I'll make this comment again when we go to the law of delict. Then you should know that South Africa has two sectors in our health care environment. We have a public sector. Those are the public hospitals. Those fall under the MEC of the province. So every person working in the public sector is an employee. Whether you are a doctor or a nurse or a physiotherapist or a speech therapist, you are working for government for a salary. On the other hand, we have a private sector. Those are doctors and hospitals that work for profit. In other words, they can choose who they want to treat or not, and usually the patient is covered by medical aid. Hospitals in the private sector are companies. They are private companies, and they are public companies, and they have shareholders and they work for profit. And if you go there, you need to pay the bill yourself, or if you've got medical aid, then the medical aid will cover that. So what is the basic difference between the two? In the public sector, because you are an employee falling under the MEC for health of your province, you do not have a choice. You have to do what your contract of employment determines. In other words, if you are a surgeon, if you are a general practitioner, you have to treat every person that walks in that door because that is part of your employment contract. Whereas if you're in the private sector, you can choose whom you want to treat or not, as long as you are not discriminating. You can choose who you allow or not. In other words, it is done completely different. And if something goes wrong in the private sector, if it's the doctor that you are accusing, you will sue that person in person. If it's the hospital, you will sue the hospital, the company, the owner, whether it be Life, Mediclinic, Netcare, whatever the case may be. So there is a difference, and I'll come back to this. And if we carry on, I will indicate to you, remember, this is public sector. Remember, this is private sector. Remember that we do not have national health insurance yet. It is in the process. The negotiation process have started. They envisaged it for 2026. And then COVID came, so I don't know whether it will be possible to have it already in 2026, but we will just keep your eyes and your ears open as things change, but it will not just happen overnight. The Constitution, then the Constitution functions always at the background. The Constitution determines the values of our whole society. In other words, we must treat each other with dignity. Everyone has the right to life. Everyone has the right to privacy, etc. So when you are faced with a possible case, something happened in hospital or with a doctor, you always think, is there something constitutionally or not? And then you go to the legislation in the field, etc. I will indicate this to you as we carry on. But remember, the Constitution is everywhere, and every law that is inconsistent with the Constitution should be challenged in the Constitutional Court, and then for them to make a determination. Then no damages. This is the saddest part of medical negligence. And you must bear with me, and you must understand this, because this is important going forward. And I'm going to explain this to you by way of an example. Let's say, for example, I have a son. My son is 19 years old. He still lives with me. He's a student. He does not have a wife. He does not have children. He is not supporting anybody. I am supporting him. He is a student. So one night he goes out to a party, have some drinks. On the way back, there's an accident. He doesn't die because of the accident. He goes to hospital. He goes to hospital, and because of negligence in the hospital, he dies. Not, okay, indirectly because of the accident, but it can be shown that it is how he was treated in the hospital. A novus actus interveniens. He died in hospital. Can I claim, me as the mother? No, I can't. Why not? because I have not suffered any damages. He was not supporting me. I was supporting him. What damage can I prove? Now you can say, yes, but my heart is broken. I lost a son. That is not quantifiable. And it is not allowed to pay just pain and suffering, not to quantify damages. Keep that in your mind. We take the same scenario. My son is 19, not a wife. He doesn't have children. He's not supporting anyone. He drives. There's an accident. He goes to hospital. Because of negligence, he becomes a paraplegic. Can we now sue the hospital? Yes, we can. Well, he can. Let's say he was 16, so he was still a minor, then I will assist him. But then we will have a huge claim because we will claim future medical cost, past medical cost, what he would have become if it wasn't that he's now a paraplegic, what he would have earned. Then we have a huge claim if he's a paraplegic. But if he died, I cannot institute any action. And that is sad. The same goes for mothers who loses a baby because of negligence. You cannot claim because you did not suffer any damages. Now I can feel that all of you think, yo, this is not fair. Of course it's not fair. But if you have to pay out for every person that suffers pain and suffering because of the death of someone, it will be even worse. The floodgates will open, and where will you stop? So I'm referring you there to a case, the Mbele case. That is one of the cases that I know of. What happened in that case is Mrs. Mbele gave birth. Because of negligence, the baby died immediately after birth. Then it was a public hospital. They took her back to the maternity ward, which is really cruel. So she was there between all the other women who had babies. Then they came and they called her to go to the mortuary and identify her newborn baby, which was also cruel. So eventually Mrs. Mbele lost it completely. She got depressed, she needed help. And then they approached the court and they only claimed for pain and suffering, but they could prove costs that she incurred because of her psychological situation. And the court awarded 100,000 rand. So if you are interested in this point, then get hold of that case, because in that case, there's reference to other cases as well. But it is not common. It is by far the exception that pain and suffering will be paid out. Remember, if you cannot prove and quantify damages, it is very difficult to claim that, if ever. Okay, so I've spoken a lot about delict and a contract. So those of you who do not have a legal background, those are the fields of law. A delict is when one person did something wrong to another person, two individuals. But it can also be a juristic person. A hospital, for example, is a juristic person. But in law, there are requirements for a delict. You have to prove there were conduct, human conduct. The conduct was wrongful. There was fault on the side of the person who violated the other person's right. And fault can be either intention or negligence. You must prove there's causation. In other words, a link between what the person did and what the outcome is, and the person who was offended or to whom the bad things happened must be able to prove damages. If you cannot prove all of them, conduct, wrongfulness, fault, causation, and damages, then you do not have a case and you cannot go to court. So in court, the judges, the advocates, they will check and see whether you have proved all of that. Now, in medical negligence under fault, of course, we're going to focus on negligence and not on intention, because I don't think any doctor or hospital will intentionally harm a patient. Huge problem to prove causation, to prove that what the doctor did is eventually the bad outcome. Isn't it just he did his job, but you reacted differently as other people on the anesthetics, something like that. So causation is difficult to prove. I'll come back to this. And then, as I've said, you have to prove damages, that you suffered damages. The other legal field is the law of contract. Now, remember, when you go to a doctor, you conclude a contract, whether it's written or not, because a contract need not be in writing. It can be orally. When you go to a hospital, the contract is more obvious because you have to sign all these forms when you are admitted in hospital. So I'm going to come back continuously to, are you claiming on the basis of delict, or are you claiming on the basis of a contract? And it is very important to know what is the difference. Why do we differentiate between the two of them? And it is basically when you claim under the delict, you yourself, okay, I went to hospital, I went for a hysterectomy, my uterus was removed, but then the doctor's hand slips and one of my arteries were perforated and I suffered a lot of blood. I ended up in ICU. I spent 6 weeks there. I come out. I am angry. I think the doctor was negligent. And I suffered a lot of pain and suffering because I was in hospital so long. I lost my job, etc., etc. That you can claim under a delict. Under a contract, you cannot at all claim pain and suffering. You can only claim patrimonial loss, proven loss. Under a delict, you can also claim non-patrimonial loss, which is pain and suffering. Keep that in mind. It will become clearer and clearer as we carry on. So we're going to start first with how the Constitution plays into this field of medical law. And see there, the Constitution of the Republic of South Africa, 1996. That is the correct way to refer to the Constitution. You do not say Act 108 of 1996. There's another act that say when you refer to the Constitution, that is the correct way of doing it. So the first important right in the Constitution, in Chapter 2, the Bill of Rights, the right to equality, Section 9. Now I want to come back quickly to the public and the private sector. The public sector, sorry, let me just switch off my phone. In the public sector, the right to equality. In the public sector, you are an employee and therefore you cannot choose whom you want to treat or not. You must comply with your contract of employment. But now, abortion. Someone, you working in the public sector, you are a doctor in the public sector, and a young girl comes to you and she wants an abortion. Remember, abortion is legal in our country because of the Choice of Termination of Pregnancy Act. But it is completely against your religion, your culture, your beliefs. You cannot show her the door or preach, have a sermon for her or convince her not to do it. Not at all. It is not expected of you to do it yourself, but there is a duty on you to refer her to someone who will do it. You cannot just leave her. You can actually be sued for leaving her or trying to convince her not to do that. You cannot do that because it's legal, but it's against your religion and your culture. You have to refer her to a place or to someone who will do that. That is your duty because you are an employee in the public sector. Bottom line is, you're an employee, you've got a contract of employment, either as nurse, doctor, or physiotherapist, or whatever the case may be. So you comply with whatever is expected of you from government in the public sector. Private sector, as I've said, there you have a choice. If you are a doctor and you do not want to work on Wednesdays, you would like to play golf, you're welcome to do it. If you just want to treat women, you are welcome. But if you say, I'm only going to treat white women, that's no-go. No, that is discrimination. If you say, I'm only going to treat women because I'm a gynecologist, that is fine. You can do that. You have that option. But you're not allowed to discriminate. In other words, you cannot have a practice just for white people or just for Indian people or just in a rural area. That is not acceptable. So you cannot discriminate because then you goes against the Constitution, and that is not allowed. A hospital may discriminate only on payment because you go only to a private hospital if you can afford it. But now, if there's an accident and people are hurt severely, and the nearest hospital is a private hospital, the people must be taken there even though they do not have medical aid. They must be stabilized at that private hospital and then moved to the public hospital. That is the right to emergency treatment. Okay, let's carry on. Human dignity is section 10. And in the case S versus Makwanyane that considered the death penalty, it was said there, human beings are entitled to be treated as worthy of respect and concern. And this is very important, that whether you're a doctor, whether you're a nurse, whether you're a patient, whether you're a cleaner, whether you're a family member, is every person must be treated with dignity. So treat patients with dignity, treat family with dignity, treat staff with dignity. But then I've added there yourself. Have dignity in yourself as well. So let's carry on. The right to life. The right to life, yes, it came out in the S versus Makwanyane case where it considered the death penalty. But to the right to life, I want to go further to the right to life. Everyone has the right to life. And this was argued in abortion, if you do not agree with abortion. But the conclusion there is that a baby, a fetus in utero, in the mommy's belly, does not have rights. That is our legal system. Only when that baby is born or gave a first breath, took a breath of air, then that person gets rights. While it is still in utero, in the mommy's body, then it has no rights. That is our legal system. And that is why It did not stand in court to argue that the fetus has a right to life because it's human rights and the fetus is not considered in our legal system yet as a legal subject. So keep that at the back of your mind, whether you agree or not, that is the legal position. The debate around the right to life have turned the other way. People argue that if I have a constitutional right to life, do I also have a right to die? And that, unfortunately, no. In South Africa, you do not have a right to die. But on the other hand, you do have a right to refuse medical treatment. But you do not have the right to ask to be killed. And I'm speaking of euthanasia. But I want you to distinguish between euthanasia, which can either be active or passive, and physician-assisted suicide. The cases that I've recorded there, Stransom Ford versus Minister of Justice. That person went to court and he said he was diagnosed and he is terminally ill. He is going to die anyway. He is in immense pain. He doesn't want to live anymore because his life has no value. So he went to court, to the High Court in Gauteng, and he asked the court for permission so that his physician, his doctor, could help him to take something, some or other mixture that will kill him. He will go in a deep sleep and he will die. Unfortunately, he died at the morning when judgment was to be given. He died. So the plaintiff died. The court gave judgment and said they give him the right to be assisted to die. But then the Minister of Justice and Correctional Services took it to the Supreme Court of Appeal. So you will see first there's Stransom Ford, that was the plaintiff, a human being who was terminally ill. When it went to the Supreme Court of Appeal, it is now estate Stransom Ford because he was dead already. Anyway, the minister took it to the Supreme Court of Appeal and said to the court, give us clarity. But the Supreme Court of Appeal said they're not going to give clarity whether it is legal or not, because the High Court shouldn't have given the judgment because the plaintiff died when the court case wasn't finalized yet. And that is sad. We would have liked the Supreme Court of Appeal to give more direction. But there's a new living person who's taking the same issue to court. It is a Mr. Haag. He is terminally ill. At this moment, he has pain, but he can control it. But it is inevitable that he will go over in a phase of immense pain. So in anticipation to that, he's asking the court now that when he reaches that stage, when he's in such immense pain, he wants to be assisted to die. The court case started in February this year. It was postponed to September, and it is in the Johannesburg High Court. So please keep your eyes open, because that may change our whole legal system. The Carter versus Canada case, 2015, is an interesting case that happened in Canada, which led to Canada now allowing physician-assisted suicide. You can also Google Dignity South Africa, or you have seen in the newspapers or over television, Sean Davidson. He was the lecturer that killed his mother out of passion because she was suffering immensely. He also helped 3 other people in South Africa who was terminally ill, who wanted to die, who had immense pain but could not help themselves. He helped them to die, and he was sentenced for 3 years house sentence. He had to stay in his house for 3 years. But a lot of people, Dignity South Africa as an association, but I think a lot of people in South Africa feel that if you have the right to life, you should also have the right to die. Let's quickly define the concepts. Active euthanasia. Active euthanasia is when the doctor will take a syringe and he will inject the patient, and that will lead to the patient's death. So that is seen as murder. You're not allowed to do that in South Africa. You're not allowed to kill a person. Even if you know the person is suffering immensely, you are not allowed to end life. That is active euthanasia. Passive euthanasia is when the doctors say, this person has been in an accident and his intestines and his organs are damaged so badly, there is just no way that he will have a meaningful life. Then they can talk to the family and they can withdraw the ventilator or withdraw the feeding. And then that person will eventually, within a week, within days, within months, die. Passively, so it's not actively, passively, the person then dies naturally. This happens in a lot of hospitals. It is not per se permitted, but people will not be prosecuted. If the medical people takes the decision that there's no hope for this person and the family are consulted and all of them say, okay, let's stop the machine and see what happens. And the person then dies naturally. That is not what we or HARC is fighting for. We are fighting for physician-assisted suicide. And that means that you get a diagnosis that you are terminally ill, you accept that, you slowly deteriorate, it becomes then unbearable, the pain that you have to suffer, yet you do not die. So every day is just suffering, suffering, suffering. There's no purpose in why you are still living. Then we want it to be legal so that a physician can come. And if you are so paralyzed that you cannot, with your own hand, take the medicine and drink it, the physician must help you to drink it. You swallow it yourself, you go in a sleep, and you die. So that is what I support Dignity South Africa, but that is what we're fighting for. But at this moment, it is illegal. It is not legal to do that in South Africa, which brings me to a living will. Maybe you've heard about a living will. Maybe you've seen a living will. You can Google a living will and you will see an example. A living will is a directive. It is an instruction that you as a living person write. You write it out or type it out. You sign it. You have witnesses that you are compos mentis. You understand what you are doing and you keep it somewhere in a closet or in a filing cabinet. So when you end up in a position where machines are keeping you alive, then either your doctor or your spouse or your children will take out that document and say, this was my mother's or my father's or my husband's wish. The doctors need not comply. A living will is not a legal document. It is only a directive, so that when they want to switch off the machines that's keeping me alive, and they don't know what my decision would have been, then they leave it to the family and they must now think, what would mother have wanted, etc., etc. If you have such a document, you help your family and the doctors to show them while you were living what you would like to happen with you when you are not capable of making decisions anymore. But remember, as our legal system currently stands, it is not a legal document. You cannot go to court on the basis of that document. It is only a directive to help the people who must take the decision to make the decision. Okay, so we've spoken about equality and that there should not be unfair discrimination. Another section very important for medical law is section 12 of the Constitution, the right to security of the person, bodily integrity. Very important. Once we discuss informed consent and patient autonomy, we will come back to this section, as this section is the bottom line of personal autonomy and to give informed consent. Then every patient has the right to privacy. And there you can also look at the HPCSA's booklets if you want to know more about confidentiality between doctor and patient and privacy. And remember, at the bottom line, the agreement is between the patient and the medical team. Nowadays, and if you are connected to a hospital, maybe a legal advisor at a hospital called me the other day and said they have a huge problem. People go into ICU, and in ICU, there's these huge medical charts at the footed end of the patient where they continuously monitor that person. If the family starts taking photos of those records, stop it immediately. It is not done. It should not be allowed. If they become angry, then immediately call hospital management. No one has the right to go through a patient's file or to take photos of the patient's file unless the patient gives them that permission, which will not happen in ICU. So the right to privacy, very, very important, because all of us have that right to privacy. The right to access to health. Very important that you do not miss that word access. Please never tell someone that South Africa, we have the right to healthcare. We don't. We don't have a right to healthcare. We have a right to access to healthcare. So that is very important. And it's the case of Subramani. At the end, when I conclude with all the constitutional court cases, I will explain Subramani. Also in the Constitution is section 28, the rights of children. Please, this is a warning to everyone, whether you are a lawyer or in the healthcare profession. If you work with children, be extremely careful. You cannot just focus on the Constitution. You cannot just focus on the National Health Act. You must consult the Children's Act, and if it concerns pregnancy, the Choice on Termination of Pregnancy Act. The bottom line of the Children's Act, the Constitution, etc., is the best interest of the child. Yet the best interest of the child is nowhere defined. So it will be case by case specific. Then also under the Constitution is the access to information, section 32. And there's a specific act promulgated in line with the right in the Bill of Rights, the Promotion of Access to Information Act. And you need to know this and take notice of this PAIA Act, because you will need that once you want to ask for documentation from hospitals or doctors. So, they're not going to give you the documents. I tell you now, it's difficult to get doctor's records, hospital records, but then you fall back onto that case. And there I have a case that you can consult if you come into such a position that you have to use that act. Also in that book that I said from Van der Heever and Lawrenson, there in that book, it is indicated to you step by step how to use that act to get documents. Because I promise you, hospital records disappear overnight. And it's extremely difficult to get it, especially from the public sector. But you can always fall back onto that act and ask for that. Okay, so I am nearly done. So there I have listed for you constitutional court cases that you can take notice of. Remember why? Because in our legal system, we have what we call the precedent system. In other words, the constitutional cases, what they have adjudicated becomes binding on all other courts. So it is important to always check in that specific field of medical law that you have to give advice or whatever. Is there a constitutional court case? And then refer to that as the highest court in our country. So Subramani was suffering from renal failure. So unfortunately, apart from renal failure, in other words, his kidneys did not work, he also had a blood problem and some other problems. So in our South African health system, if you have kidney failure, you must go on dialysis. But you can only go on dialysis if you are a candidate or healthy enough for an organ transplant. First, Mr. Subramani went to private sector. Then all his funds were depleted. So he went to the public sector in KwaZulu-Natal and he asked the public sector to accommodate him on a dialysis machine. And the public sector said, no, they're not going to, because he is not healthy enough to get a possible transplant. He suffers from more than kidney failure. It eventually ended up in the Constitutional Court because Subramani argued, but he has the right of access to healthcare. He has the right to life. He has the right to emergency medical care. But the Constitutional Court said that kidney failure is not emergency. So that one was overruled. He has access to healthcare, so there's no doubt about it. He can go to a public hospital, but he has to comply with their policies. And their policy is that if you are not a transplant candidate, we will not accommodate you. Apart from that, the hospital that he went to in the public sector did not have enough dialysis machines. And the Constitutional Court said that in the public sector, there must only be supplied to patients with that which they have. In other words, this judgment becomes an easy way out for the public sector to say, oh, we're just sorry, we don't have the equipment. We don't have the logistics. It's just sorry, we don't have enough money. We don't have enough beds. I wish someone will challenge this court case, because this court case confirmed within the means of that hospital. And now the public sector does nothing and they say we just don't have the means. Anyway, read the case yourself, make up your own mind. Tshabalala Mzimang, that case concerns privacy. If you can think back, those of you that's as old as I am, Mrs. Tshabalala Mzimang was the Minister of Health. She needed a liver transplant. She got a liver transplant very quickly, whereas other patients have to wait years. And then it was exposed in the media and it was taken to court, and she argued that they violated her right to privacy. Although it did not go to the Constitutional Court, it considered a constitutional right, the right to privacy. Age versus Fetal Assessment Center. I will come back to this one. What it basically means is in South Africa, when a gynecologist is negligent and the baby is born with abnormalities, in other words, the mother got pregnant. She went to a doctor, a specialist. In this case, she went to a center who specializes in pregnancies. And she said to them, do tests to see whether this child that I'm carrying is healthy. They did the test. They interpreted it negligently. They said to her it's a healthy child, and eventually a disabled child suffering from many things were born. And then the mother sued the fetal assessment center. But the mother couldn't, because it was already 3 years. The baby was already 6 years. So the parents couldn't because of prescription. So the parents, the baby, the Down syndrome boy sued. The parents assisted him. And then the High Court said you can't do that, because if the child institute the action, it is what we call in our legal system a wrongful life claim. In other words, the child then argues, I should never have been born. If you did not give the wrong information to my mother, I would not have been born, and I would not be suffering as I am suffering at this moment. That was an illegal basis of claim. It was no cause of action in our legal system. But this case went to the Constitutional Court, and the Constitutional Court said that this is now a valid claim depending on the circumstances. But children can now sue in their own name if the gynecologist giving advice to the parents were negligent. There's a few requirements, but I'll deal with that in another session when we discuss this again. Lee versus Minister of Correctional Services, that is a difficult case. It is a thick case to read, but it is extremely important if you want to know more about causation. What happened there is this guy went to correctional services and contracted TB and then sued the Minister of Correctional Services. And the causation was the issue. So whenever you've got any doubts about causation, go back to the Lee case and you might get some guidance. Oppelt versus the head of the Department of Health, Western Cape. This was a rugby player that hurt his neck in a rugby game and was sent from pillar to post in the public sector, from this hospital to that hospital to that hospital, and eventually ended up paralyzed. And he sued the public sector and said he was denied his right to emergency medical care because of a protocol at a hospital. They moved him to another hospital and there was a time lapse, and that is why he was now paralyzed. Very, very interesting case. If you have nothing to do on a Saturday evening or a Sunday evening, instead of Netflix, read the cases. It is so interesting because in Oppelt, you've got two teams of experts, one for the patient, a team for the patient, and a team for the Western Cape province. And both seem to be fine. Now, how does a judge decide which one to believe? And it is on the basis of logical reading, of logical reasoning. My heart, in my deepest heart, I feel the judgment should have gone with the other side. But that is just my feeling. I found the legal team on the side that the court accepted arrogant, and according to me, I would not have gone that way. But that's my opinion. Then the one last there is the DZ case. Very interesting. In that case, That case concerned a development of the common law. According to our common law, now our common law, for those of you who do not know the law so well, our common law is the law that we inherited. It started with Roman law, then Romans invaded the Netherlands and it became Roman Dutch law. And it came to the Cape Colony via Jan van Riebeeck in 1652. But the English settlers also came to South Africa and brought with them the English legal system. And we have the customary law, but that what was not written down, so it's more difficult to combine that into the Western way of doing. But according to the common law, in other words, how it used to be done over many years, when you claim damages, you claim it once, and it must be paid in one settlement. In that case, it was argued it has become too heavy a burden for the provinces that they cannot pay once and for all anymore. The courts must now give judgment and say, okay, you are claiming past medical cost, we will pay that. You are claiming future medical cost. We're not going to give you an amount now. We will pay as and when it becomes necessary. You are claiming the loss of amenities of life. In other words, this child could have become a teacher. Now she's paralyzed. She can't anymore. Now you claim that money. We will pay that in installments. In other words, in that case, they went to court and they argued, change the common law so that the once and for all rule be changed. And the court said, yes, it's possible, depending on each case. Same as the fetal center, you can claim wrongful life depending on the specific facts of each case. In DZ, you can claim for installments or to pay with providing the medical service instead of rands, depending on each case. So remember that if you get confronted with such a scenario, that you go back to the Constitutional Court case. Okay, I think you are tired. I am nearly done. I want to refer to these cases. As you will see, what do you see? 2022, 2022, 2021. So these are new cases. And what is amazing, even for me as the older person, that if you know about a case that's coming up, and I think they have it on the website for a time, I don't know when it disappears, but you can actually go on a link and be virtually in the Constitutional Court when these cases take place. For example, I attended the one of the Tembisa Hospital. It was amazing. So you just log into you go to the website of the Constitutional Court and you can see the YouTube video of this whole court taking place. And you can hear the lawyers arguing, you can see the reaction of the judges. It is amazing. But these cases, if you want to read cases, read these cases because it's new. Nowadays, every medical negligence case wants to go to the Constitutional Court because the Constitutional Court have broadened their jurisdiction. But it's very difficult to be successful in the Constitutional Court if there is not a point of interest to the public or some or other right in the Bills of Rights have been violated. So the one of let's see that one, the government versus PN, the last bullet there. That also, that links with the DZ case on the payment in rand and once and for all. So that one links with that case. It is just a newer judgment than the other one. Then the one of NVM and the Tembisa Hospital. People, read this. Please don't look at Netflix. Read this case. It was 9 judges. No, it was 10 judges eventually. 4 judges were the minority judgment. 5 judges gave the majority judgment, and then the acting Chief Justice, he was at that stage acting Zondo, gave a concurring judgment with the majority. But if you read this case, see how differently even judges look at medical negligence cases. 4 judges felt a certain way and supported that it was in the interest of the public and it had therefore a constitutional connection. But the other 6 said no, there was nothing. But it is extremely interesting to read the facts, their reasoning. So if at all possible, read that case. Then the one on TM on behalf of MM, also a 2022 case, and it's a unanimous judgment which said there's nothing for the Constitutional Court to engage. It was facts and it was pure negligence. Okay, let's see. Last slide. The voice of the unborn baby and another versus Minister of Home Affairs. That is if you are interested in the broader spectrum of medical law and not just medical negligence. According to the Birth and Death Registration Act, if a baby, a fetus in the mother's womb aborts naturally, it is a miscarriage. And it must go for medical waste. Even if the parents wants it, it must go for medical waste. If the baby is born after 26 weeks in utero, which is actually very difficult to determine precisely, then it is registered as a stillbirth and the parents can then have a burial or a cremation for that fetus. We, and I was part of the team, we felt that is unconstitutional, it's discriminating because every woman experiences a pregnancy different. Some women will lose a baby at 4 or 5 weeks or 16 weeks or 19 weeks, and they would want to say goodbye and have a burial or a cremation to get closure. But they can't. If it is, let's say you expect twins and you lose the one at 20 weeks and the one at 27 weeks, then you've got one body to have a burial or cremation. Anyway, we went to court. We went to the High Court. We won in the High Court. The judge said it's discrimination and it should be the mother's or the parents' choice. Went to the Constitutional Court. And the Constitutional Court did not give judgment in our favor because they argued that the Birth and Death Registration Act is not applicable. So we must go back to the drawing board and think again. It's very interesting. If you are interested in that, I think you can also still watch the recording of the Constitutional Court, or you can just read the case, or you can engage with me if you are interested. Last case, Van der Walt versus S. This is very interesting, and I think it's part of your activities. This is significant. All the others were civil cases based on delict, etc., etc. This one was a criminal case. A criminal case. Now, a criminal case is completely different from other cases. It goes to a criminal court, and you will see it is S versus Van der Walt. That is where it started. So he then appealed. What happened there is this woman wanted to give birth naturally. The gynecologist, Dr. van der Walt, told her, you are too small, it's going to be problematic. She said, I want to culturally. And he said, okay, fine, just remember, but I'll help you. You can deliver naturally. The woman went into labor. Van der Walt wasn't there. The doctor, they called him. He came. He was allegedly under the influence. The baby gave birth. The baby was eventually sucked out. So the woman was ripped apart from her vagina to her anus. The doctor then repaired, stitched her together, not in the way he should have done. And he went home, and he was called a few times to say that the woman kept on bleeding, and he gave instructions. He eventually came early the following morning, but then the woman died. So she died of a loss of blood. So if something like that happens, what are the choices? You can report the doctor to the HPCSA. Then you state your case, they will do an investigation, and the only satisfaction that you will get is that the doctor will then be punished by the professional board. In other words, he will get a fine, or his name can be removed from the register. Or you can institute a civil claim on the basis of contract or delict, as I've said, but the parents then argued they can't do it because they lost their child. So what damages did they suffer? So that will be extremely difficult. And then they used the third option, and that is they went to a police station and they laid a claim against the doctor on criminally that he was negligent and that he is responsible for the death of their children, which in criminal sense is then manslaughter. So he did not have the intention, he was negligent. So the regional court found him guilty. Then it went to the High Court. The High Court found him guilty. He was sent to prison for 5 years. He appealed to the Supreme Court appeal. The appeal was not allowed. And then he went to the Constitutional Court. And very interestingly, read the case and see what the Constitutional Court did. They only focused on the technicalities and not the merits. And yes, I'm not going to tell you what happened. You can read the court case yourself, as I think it is one of your activities. Let's see. Okay. I just quickly want to see, are you... Okay, not so much. Okay, I didn't know. I carried on. Okay. As I said, you can sue on the basis of a contract, a delict, or you can have both. So nowhere in medical law is it said that you must go on the basis of a contract or you must go on the basis of a delict. You can go on both. What are the requirements for a contract? Consensus, capacity to act. It must be physically possible. It must be legally possible, and you must be able to prove damages. If you want to see a case, then you can read the Administrator of Natal versus Edward. This woman asked, she went to the provincial hospital. She wanted to be sterilized. They didn't want to have children anymore. The sterilization was not successful. She became pregnant and then she sued the Administrator of Natal. You can see it's 1990. So it's pre-New South Africa. So it's before we got premiers, we had administrators. She sued on the basis of contract. She proved the damages that they must now look after this child until this child is self-supported. So that claim was awarded to her. She did not claim pain and suffering for the giving of the birth because she couldn't, because they instituted action on the basis of a contract. Read that case, old case, but interesting. The Afrox versus Strydom case, and I apologize, this is a Supreme Court of Appeal case, but it is only reported in Afrikaans. I don't know why they did it, but if you Google it, you will see summaries of it in English. But it basically means that this straight-on person went to hospital, signed the admission form. In the admission form, there was an indemnity clause that the hospital is not responsible for any bad thing that happened with you in that hospital, even intentionally or negligently. And then Strydom refused to sign it. And then they said, but then we're not admitting you in hospital, took it to court. Afrox became the Life Hospitals. And then the Supreme Court of Appeal said that indemnity clause is valid. It's absolutely valid. But the judgment came in 2002. Since then, we had the enactment of the Consumer Protection Act, and I don't think that will stand anymore. So should something like that happen again, or you want to challenge the admission forms in a hospital, do it on the basis of the Consumer Protection Act. And I think then you might be successful. So there I have just once again recorded the requirements for a delict. Then is there a duty to treat on the side of the doctor? No, there's not, except, remember, in the public sector, when you're an employee, you comply with your contract of employment. Private doctor has a choice as long as he or she is not discriminating. But there is a duty to complete the treatment. Once a doctor has started, there is a duty on the doctor to complete the treatment. Otherwise, you can sue him. If he or she cannot complete the treatment, they must refer you to a person who can do it and who can complete it. Is there a duty to get informed consent? Absolutely. Absolutely. If you did not give informed consent, then the doctor is assaulting you. This is a huge problem. This is a lot of medical negligence cases go to court because the patients say, but I've never given informed consent. What does informed consent mean? Castell versus de Greef is the locus classicus, or is the court case that fixed the standards how to determine informed consent. But you will also, if you read the National Health Act, section 6, 7, 8, and 9, that will give you guidelines on what is informed consent. The Consumer Protection Act explains what is informed consent. It basically means that whatever is going to happen to you should be explained to you in a language that you understand, on a level that you understand. In other words, there are two things. You must understand the language or get an interpreter, and the level, your level of literacy must be taken in account. And it is the duty of the doctor to get the informed consent. You can also read booklet 4. And then there are 3 cases, Isaacs versus Pandy, Pandy versus Isaacs. Those 2 cases, the one is the appeal, is where the person alleged that she did not give informed consent for a sterilization. There's a little snag. The Sterilization Act requires consent to be in writing. So there's issues there, but if you want to know more about informed consent, you can read those 3 cases. The standing one at this moment, the president, is RB versus Smith, which went to the Supreme Court of Appeal. And once again, my heart feeling, I disagree completely with that judgment, but with respect to the judges of the Supreme Court of Appeal, that is how they interpret it. It's the judgment, and I must respect that. But I think I would have given a different judgment. Okay, a delict just means there is a general duty of care. The doctor must look after you to the best of his abilities, and there's a standard of care. It differs for every profession. A general practitioner is different from a surgeon, is different from a gynecologist, is different from a psychiatrist. But every field has its own standard of care. And that is where I'm going to end, because we will carry on from this point in the second webinar. Just quickly, one student contacted me and said previously in the previous semester that when he did the multiple choice questions, the test 1, the question, there could be a question speaking to the objectivity of the standard of care test, which is the reasonable doctor test. And he argued that it is not an objective test. And I hear, if we are going to split hair, it is not completely objective, but it is considered to be an objective test. And then just note that a preponderance or balance of probabilities, the same thing. That is how you prove a case of medical negligence in a civil court on a balance of probabilities, whereas in a criminal court, you have to prove it beyond reasonable doubt. But preponderance or balance are just different words, but it means the very same thing. So I'm going to end the show. I'm going to switch that off, and I'm going to switch on my camera. Okay, there you see me. Okay, now the floor is open. You can ask me questions. I apologize for talking so much. Digest, but you can now interact with me. So just put up your hand. Let me just see who is putting up hands. Wesley, you can ask your question.
Thank you very much. Currently,
Just unmute yourself, speak louder.
Currently, I file a case in the High Court of my client that they were supposed to do the operation on the left leg. And after 20 minutes during the operation, they found out, listen, this is the wrong leg, it must be the right leg. Okay, I haven't got the problem to sue the doctor. The doctor was an independent contractor who worked at a certain hospital. Now, to come back to the responsibility of the nurses in the theatre. A certain hospital, this is a private hospital, they argue that this nurses was working for the doctor. And that is not true. They were employees according to Section 200A of the Labour Relations Act. You remember that there's about 8 factors that you must consider when is a person in independent contractor or a nurse. What is your outcome of this type of case where they say that the nurses is not working for this hospital, but they may receive their salary, working hours, etc., everything from that private hospital?
Okay. I'm just going to tell you a scenario quickly, and then I'll come to the answer. So my own sister had to go for a leg operation at a private hospital in Johannesburg. She had polio as a child, so the one leg is thinner and shorter than the other one. So it was on this shorter and thinner leg that the operation should be done, because she's getting older now, and now the knee needs a replacement. We were at the hospital. I was with her at pre-op. And just as a matter of interest, because this is my passion, I observe and I'm everywhere in the hospital. I looked at her wristband, and there they said the right leg will be operated on, but it's the left leg.
Yes.
So I called the nurse, I opened up the duvet and I said, this is wrong. Can you see? there is the leg that needs to be operated on, yet on the wristband, it is stating. And the nurse looked at me and she said, but all the documents say. I say, but you can you see? Can you see this is not the case? And she was actually furious with me. So I took a pen and I changed everything. But now, fortunately, nothing happens. In your scenario, things now went wrong. I will sue the doctor in
Yes,
person
Yes.
because I feel he or she should have checked and should have, because it's private hospital, should at least have known the patient, because he is responsible to get the informed consent. So I will sue him, and I will sue the private hospital
Yes.
and the nurse in person. Okay, nurses are very difficult because very few nurses nowadays are employees of the private hospitals. The private hospitals work on skeleton staff, so they have a few nurses employed by them. The others come from companies, recruitment companies that supply. So let's say this hospital all of a sudden have so many orthopedic surgeons, they do not have enough nurses. They call these agencies, and the agencies supply the nurses, who then at the end of the day are not employees of the hospital,
Okay.
but basically employees of this recruitment organization. The hospitals stay at the end of the day still responsible for those nurses, and they need to come to court and indicate why they are not responsible for them. Another scenario is that you get in some hospitals, I know specifically one here in Pretoria, where a whole wing of the hospital is owned by one doctor or a group of doctors, and they employ their own nurses. I will then sue them, the doctors, even though they were not part of I will sue them vicariously as the employers of the nurses. I will do the whole spiel, and then each one of those parties will have to indicate why they should not be included in who I am suing. Do you hear what I say? So I will go for the doctor who performed the operation and on the wrong leg. I will sue the private hospital. I will sue the nurses in person. I will sue the employers of the nurses as well.
The next question. Sorry for my Afrikaans now. What about the narcotiseer?
The anaesthetist. In the next or the third webinar, I'm not sure, I'm going to talk about this. Unfortunately, in the UK, you have a principle of the captain of the ship, where you've got two surgeons, a neurologist, a pulmonologist, and an anaesthetist in the hospital, in the operation room. In the UK, one of them is in charge. That does not apply in South Africa. We do not follow the doctrine of the captain of the ship. And each one, the anaesthetist, the surgeon, the pathologist, they are all independent contractors. So the one is not responsible for the other. The most that can be done to the anaesthetist is to get him as a witness or something like that. But he must be sued in his own name. Depending on the facts, I'm now speaking generally, I do not know the exact facts. If there is any indication that he should have looked or that he was also negligent, then sue him as well. And he must come to court and say why he should not be sued. But he's an independent contractor. They're not working as a team. Each doctor is completely an independent contractor.
Ma'am, thank you very, very much.
I'm going to tell you just one little story quickly again. One wonders who is responsible, who must talk to the family. And I'll give you an example. One day my husband went into an operation for his neck. So you had an orthopedic surgeon, the neurosurgeon, because his spine was also there, and you've got the anesthetist. So I was sitting outside the operating room knitting, waiting. It was hours later, and the nurse kept on walking up and down, and she asked me, "Why are you sitting here the whole day?" So I say, "I'm waiting for my husband. He's in the operation room." She said, "Did he get a neck operation?" I said, "Yes." She said, "He goes immediately from the operating room to ICU. I will not see him." I was furious, and I thought to myself, no one, not one of those three came out, not even the sister, to speak to me and say, "Okay, everything went fine, your husband is fine." And I threw a tantrum of note. And then the same question came, "But who should? Who's responsible to come and talk to me?" That is a huge problem in our legal system, that they are all independent contractors. Not one takes responsibility for the other. Quick other example. My hairdresser, very small woman. She has a blood problem. She was advised not to get pregnant. She got pregnant. So on the day that she had to deliver the baby, everyone was there. The gynecologist, a surgeon, her general practitioner, a hematologist to look after her blood, the anesthetist. They were all there because they thought she's not going to make it. The baby was born perfectly. She was fine. But then her blood sugar and her blood pressure went so low, she needed oxygen. And guess what? A private hospital here in Pretoria, guess what? There was no oxygen in the cylinder. Who was supposed to check? So fortunately, the gynecologist jumped onto her and did mouth-to-mouth resuscitation, and she survived. She cannot institute an action because she didn't suffer damages. She and the baby survived. But who was responsible to check that there was oxygen in the cylinder? Now, we can say hospital management, but shouldn't the anesthetist also check? I don't know. That is the problem. No one is in charge in our legal system when something goes wrong. You have to sue the whole lot as individuals.
Thank you very, very much for your answer.
Thank you. Anyone else? Let me just see if I see another hand. Anyone? Another hand? If you someone raised his hand, I can't see. Just speak. Daniel Jacobus, you can speak.
Good afternoon, Prof. Slabbert. How are you?
Find yourself.
Good, thank you. This is with regards to the activities. I just wanted to make sure you mentioned that it was we can treat it as a comprehension test. Does that mean we can use the wording of the cases, or do we have to interpret it and put it in our own words as well?
Did you do legal philosophy at UNISA?
Yes.
No. I'm testing whether you have read the case.
Okay.
I don't care about referencing at all, because
Okay.
according to me, you only work with one source, that is the case. So
Okay.
you answer directly from the case. I want you to read the case to get the principle, to understand the principle. This is not a research exercise. So no referencing, it's not necessary at all. You
Okay,
treat
so
it as a comprehension test.
Okay, so we can use well, our answers can be exactly as it is in the case.
Yes.
Okay,
Yes.
perfect.
All I
Thank
want
you
to
very
see
much.
is whether you understood the case. That is all. Okay,
Okay.
so don't
Thank
worry
you.
about referencing. Okay, anyone else? I don't see another hand. Okay, so this is the first webinar. We're going to have another two. As I say, I apologize. It's a lot of information. You will get the slides, and it's now up to you to go through the theory and the work yourself. And when you're ready, you do test 1. But for the activities, try stick to the dates that we've given you. Otherwise, you're going to fall behind and the work just becomes too much. Okay, so if there's no more questions, good luck. And until we see each other again, good night. I'm going to have a glass of wine now, but have a good evening.
Thank you.
Bye-bye.
Bye.
Thank you, Prof.
Sorry, Prof.
Thank you, bye.
Prof.
Yes.
May I ask you a simple question, a stupid question, please?
No question is ever stupid. Yes, ask.
I see in some of the questions you asked, what is stated in so-and-so cases? Means that what is this case about, or what was the outcome of a case?
What is the case about?
Yeah, you
Is
say
the question
you
just
asked.
as vague as that?
Yes, no, it's. Sorry, Prof. It's a stupid question, but I'm a little bit confused. Sorry for this one, but
No. Let me
you know
just.
the question is being asked. I think is this portfolio number 1. What is stated in
Okay.
so and so case?
I'm
that
just quickly.
I think it's question number 4, 5, or 6.
Well, yes. What was stated in Van Wyk versus
That's right.
Lewis? Then, in the case that you're reading, the judge will be referring to the Van Wyk versus Lewis case.
Yes.
And say, in the Van Wyk versus Lewis case, this was stated. So you just give that.
Okay. Thank you very much. Thank you very much, Prof.
Okay, are you with me? Do you understand what I said?
Yes, I understand that. Thank you very much.
Okay.
And thank you for the class. Well done.
Thank you. Thank you for attending. Okay, we will meet again in the second webinar. In the meantime, if you've got other questions, send me an email. No problem. Okay. Good night.
Thank you. Night.
Good night.